Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. ఈ వీడియోలో మనం కెన్ ఎ ముస్లిం మ్యాన్ గెట్ డివోర్స్ అండర్ ద ప్రొవిజన్స్ ఆఫ్ ఫ్యామిలీ యాక్ట్ 1984 ఆర్ నాట్ అనే దాని గురించి విశదంగా చెప్పుకుందాం. Muslim law, you all know there are no specific law like Hindu Marriage Act, Special Marriage Act, Christian Marriage Act. They have their own the so-called personal law. There are no sections. Of course, a couple of acts are there. That is when Rajiv Gandhi was there, that Shabano case. Shabano case, at that time, Muslim woman or Muslim woman divorce, remember, Protection of Divorced Muslim Women's Act or something. 1985 has come. I think it is still in force. Then another act is called, that is Muslim Marriages Act 1939. According to Shariat Act, it is also in force. So here the point is, can husband get divorce under Muslim Marriages Act 1939 or Family Courts Act 1984? This is the question. Now it is decided by the Honorable High Court of Madhya Pradesh, now Gwalior bench. In the case of Muhammad Shah versus Srimati Chandani Begum or Chandani Begum. Appeal number 1199 by 2022. Decided on 7/1/2025 by two judges bench, Honorable Justice Anand Pathak and Hirdesh. They clearly observed that the provision of Dissolution of Muslim Marriage Act 1939, a male cannot get decree of divorce. Under the Muslim Marriages Act, a male cannot get divorce, decree of dissolution of marriage. Then what is the other nature? Of course, you all know Saira Bano case, triple talaq case, that also came as an obstruction for them. So now Triple Talaq Act is there. So when Muslim Marriages Act 1939 does not apply, because secular provision is there, secular act is there, that is the Family Courts Act 1984. Under Section 7 of the Family Courts Act, anybody, maybe a Muslim, maybe a Christian, maybe a Hindu, yes, since it is a secular provision, the Muslim person also can get a petition filed and get the so-called decree of divorce after proper trial by the court. This is what is stated. Beautiful judgment. So, Section 7, let us understand what Section 7 of the Family Courts Act says. As per Section 7 of the Family Courts Act 1984, the court can entertain and pass orders or injunction orders arising out of marital relationship. If any dispute or if anything arises out of marital relationship, they can approach the court under Section 7. This provision does not distinguish on the basis of caste and community. That's why in the beginning I mentioned that it is a secular provision. So distinguish basing on the caste, it does not distinguish basing on the caste and community. That means it's pervasive in nature. Universal, national అన్నాను, యూనివర్సల్ అంటే బాగోదు కదా. సో ఎవరికైనా అప్లై అవుతుంది. రైట్, ప్లీజ్ రిమెంబర్, as far as the Shariat law is concerned, please remember, it is regulated by the so-called Family Courts Act. Right. Kani, on 18/5/2022, when the so-called Muhammad Shah, he filed a case before the Family Courts Act in Datia అనుకుంటా ఊరి పేరు. The family court dismissed the petition. Family judge Datia dismissed the petition of Mr. Muhammad Shah on the grounds of maintainability. Grounds of maintainability. సో లాయర్స్కి తెలుస్తుంది, స్టూడెంట్స్ గుర్తుపెట్టుకోండి. నార్మల్గా ఈ జ్యూరిస్డిక్షన్ అనేది Section 9 ఆఫ్ ది సిపిసి, సరే వాట్ ఎవర్ సివిల్ కేసులో తీసుకుంటారు, 16 to 20 అంతా డిస్కస్ చేస్తాం మనం. దీనిలో మెయింటైనబిలిటీ అంటే మెయింటైనబిలిటీ ఆన్ బిహాఫ్ ఆఫ్ ది జ్యూరిస్డిక్షన్. ఎలా నువ్వు వేస్తావయ్యా, ముస్లింకి పర్సనల్ లా దీంట్లో రాదు అని చెప్పి జడ్జి గారు అన్నారు. దాని మీద ఆయన హైకోర్టుకు వచ్చారు. సో రైట్, సో ఈ కోర్టుకు వచ్చినప్పుడు యాక్చువల్ ఒక్కొక్కసారి మర్చిపోయాను, కేస్ ఫ్యాక్ట్స్ తెలుసుకోవడం మంచిది, ఇంపార్టెంట్. ది మ్యారేజ్ ఆఫ్ నిక్కా అంటారు కదా, మ్యారేజ్ ఆఫ్ husband, this Muhammad Shah and Chandani Begum. It was celebrated on, I think, 1910-2007 as per Muslim rituals and rites, right? And actually, she, out of love and affection, or after the marriage, 4 children, 1 boy and 3 girl daughters were born to them. But Muhammad Shah observed that their relative, Sharafat Ali, his name is Sharafat Shah. Sharafat Shah is a regular visitor of the house, and he is suspected there is intimacy between his, or illegal intimacy with his wife and that man. Lot of troubles, disputes. Ultimately, it so happened that on 17/1/2016, when he came back from the work, he could not find the wife and the son. That means Sharafat Shah and this woman, Chandani Begum, both of them eloped from the house along with 1 boy, leaving the 3 daughters. Poor man, he was rearing, or he was growing up those 3 children. To his bad luck, it was known that she and that Sharafat Shah, they have been residing in Gwalior or some other place. And she has given birth to another male child on 17/1/2016. So, 17/1/2016, they eloped, and 4/4/2017, correction, 4/4/2017, she gave birth. So now, immediately, basing on the adultery, he filed a case. Local Family Courts Act does not take it up, and therefore the matter was brought to the notice of the Honorable High Court. So here, Section 2 of the Shariat Act, it covers all aspects of Muslim life. So therefore, Honorable High Court of Madhya Pradesh clearly stated that yes, Section 7 of the Family Courts is applicable. It is a secular provision, bereft of caste or community. This applies. Come on, take action as per this provision, and the appeal is allowed. So now the ball is in the court of, in the family court. They have to decide. Thank you.